Good afternoon, everyone. I am Alexander Brown. I am a barrister at 1 Essex Court, the Chambers of Lord Grabbanner QC. I was called back in 2009, which amazingly was 13 years ago. Now it doesn't feel like that. This afternoon, I am going to be speaking about penalty clauses. I plan to speak for about 40 to 45 minutes or so, and then there will be a time for questions at the end. I plan to start by outlining the distinction between penalties and liquidated damages clauses and explaining some of the points which historically have made this a slightly confused area of the law. I will then go through in some detail the latest word from the Supreme Court on penalty clauses in the leading case of Cavendish. I plan then to discuss briefly how Cavendish has been applied by the courts, and we'll be looking at two cases in particular which have applied it, both of which illustrate how penalty clauses are identified in practice. And then finally, I plan to draw the threads together into some practical tips for drafting contracts in a way which avoids clauses being defined as unenforceable penalties by the court. So with that in mind, the starting point when thinking about penalty clauses is to understand the distinction between penalties on the one hand and liquidated damages clauses on the other. It is, of course, open to contracting parties to agree the consequences of one party breaching their obligations under the contract. How that works is that if one party breaches its primary obligations under the contract, the parties are able to include a clause which sets out the secondary obligations which will arise in those circumstances. So typically, the primary obligation will be a normal contractual obligation to do something. And the secondary obligation will usually be the payment of a sum of money. In short, break the contract and pay a sum of money. These types of clauses may be classified by the court as either a penalty clause, which is unenforceable, or a liquidated damages clause, which is enforceable. So the distinction is obviously very important. And the decision as to whether a clause is a penalty or not is for the court, not the parties. So although the parties can agree the content of the clause and can say what they think it is, they can't actually determine for themselves whether it is a penalty or not, except by anticipating how a court might interpret it. And so that obviously raises the question of how we can tell the difference between the two and how we can draft contracts, draft clauses which fall on one side of the line or the other. And that is the topic of this talk. The answer might well seem instinctive. If you and I have a contract for me to build a house, which includes a clause that you will build a roof of satisfactory quality, we might include another clause that says, well, in the event that the roof leaks, you must pay me £100. And those types of clauses are popular because they provide certainty and prevent the need for contracting parties to embark on a complex and expensive quantification exercise to determine the actual value of the loss caused by the breach. They can just look to the contract where they have contractually agreed the value of the loss and the sum of money to be paid. So in this example, if there's a leaky roof, I can see that the builder has to pay me £100 to compensate me for my loss, and that looks like a straightforward liquidated damages clause. But what if the contract said, in the event that my roof leaks, you must pay me £5 million? Well, instinctively, that seems to be an unfair penalty. A roof which doesn't leak can't possibly be worth £5 million to me. So the purpose of the clause looks like it is to punish you, to penalise you for doing a bad job. And it's these sorts of penalty clauses which a court will consider to be unenforceable. But the line between a liquidated damages clause and a penalty clause is a very difficult one and raises a number of questions. So is the distinction simply based on the size of the sum agreed? How closely does the sum agreed in damages have to reflect what a court would consider to be the actual value of the loss? What if my not having a leaky roof is so important to me that I genuinely and subjectively believe that it's worth £5 million? There's all these sorts of really quite difficult questions. Fortunately for us, the Supreme Court recently reconsidered the question of what is a penalty clause and fundamentally overhauled the law in this area. So there really is only one judgment you need to know, and it actually involved two joined cases called Cavendish Square Holding and Makdessi, and ParkingEye Limited and Beavis. The two joined cases dealt with exactly the same legal issue, penalty clauses, but their facts could not have been more different from one another. It's worth just briefly going through the facts because the relevant contractual clauses under consideration, at least in Cavendish, were slightly unusual. Cavendish was a case involving two very experienced commercial parties. They had reached an agreement for the sale of a controlling interest in the defendant's company, and that agreement had followed detailed commercial negotiations in which both sides were represented by top commercial lawyers. And the claimant had agreed to pay a purchase price of up to 147 million US dollars, payable in instalments, and a large portion of that sum reflected the goodwill in the business. The agreement provided that after the sale, the defendant would not compete with his old business, and that if he did, he would not be entitled to any further instalment payments under the contract, and the claimant would acquire an option to buy the remaining shares in the business. That's the key bit. In the event the defendant did breach the non-compete clause and the claimant sought a declaration that the defendant was not entitled to the further payments and was obliged to sell his remaining shares to the claimant. The defendant argued that the clause was unenforceable because it was a penalty. So that's Cavendish. The other joined case was ParkingEye, where the defendant parked his car in a car park managed by the claimant, and despite large signs at the entrance stating that parking for more than 2 hours would attract an £85 fine, the defendant very naughtily parked his car for nearly 3 hours, a situation I'm sure many of us may have been in at one time or another. And he alleged that he did not have to pay the fine because the £85 fine was a penalty. So as I say, two very, very different sets of facts, but both of which raised precisely the same legal issue. Before turning to the decision of the Supreme Court, I'll just give a very short legal background of where we were before Cavendish. Prior to this case, it was thought that the correct test to establish whether or not a clause was a penalty was whether it represented a genuine pre-estimate of the loss. That is the test you probably learnt in law school. It's definitely what I learnt, and it came from the judgments of Lord Dunedin in Dunlop Pneumatic Tyre and New Garage and Motor Co. In other words, if the sum contained in the clause was a good faith estimate of the loss that the innocent party would likely suffer if the other party was in breach, the clause would not be considered a penalty. And following Dunlop, this was the test that was consistently applied by the courts. Either a clause was a genuine pre-estimate of loss or it was an unenforceable penalty. But that approach led to a whole host of problems which are outside the scope of this talk, and there were authorities which really questioned and challenged this distinction. It started to get blurred, and there were significant calls for the abolition of the rule against penalties altogether. And indeed, that is what counsel for the claimant in Cavendish argued. And they said that the rule against penalties was an unjustified interference with freedom of contract, particularly where the parties have equal bargaining power. And second, it was also argued that the growth in statutory regulation of contracts meant that the rule against penalties was no longer necessary in modern law. Counsel pointed to the unfair terms in consumer contracts regulations as an example of legislation which they said had effectively overtaken the rule against penalties. Lords Neuberger and Sumption gave the leading judgment jointly. And interestingly, they began their judgment by recognising the strength of the argument for the abolition of the rule against penalties. At paragraph 3, you can see on the screen, they said this: "The penalty rule in England is an ancient, haphazardly constructed edifice which has not weathered well, and which, in the opinion of some, should simply be demolished, and in the opinion of others, should be reconstructed and extended." You might well think that wasn't a promising start for the rule against penalties, but ultimately the Supreme Court decided not to abolish the rule, and we'll come to their exact conclusion in a moment. But before we do, it is helpful to see how we got there, how they got there. Lords Neuberger and Sumption thought that the main issues in dispute could be divided into two questions. First, in what circumstances is the rule against penalties engaged? And second, what makes a contractual provision penal? And I'll look at what they said about each of those questions in turn. First question, in what circumstances is the rule against penalties engaged? And Lords Neuberger and Sumption considered two key points: the distinction between primary and secondary obligations, and whether the application of the rule against penalties was limited to clauses for the payment of a sum of money. And in considering the question of when the rule against penalties is engaged, their lordships were understandably keen to reach a conclusion which interfered as little as possible with freedom of contract and the ability of contracting parties to allocate their own risks without outside interference. And their lordships dealt with this concern by recognising that the rule only interferes with secondary obligations, the consequences of breach, not primary obligations. At paragraph 13, they said this: "There is a fundamental difference between a jurisdiction to review the fairness of a contractual obligation and a jurisdiction to regulate the remedy for its breach." And they carried on, leaving aside challenges going to the reality of consent, such as fraud, duress, and undue influence. The courts do not review the fairness of men's bargains, either at law or in equity. The penalty rule regulates only the remedies available for breach of a party's primary obligations, not the primary obligations themselves. So Lords Neuberger and Sumption drew a distinction between primary and secondary obligations and held that only secondary obligations were capable of being construed as penalties. And they stressed that this was not a novel proposition and had always been the basis of the rule against penalties, despite some confusion in the earlier cases. This statement has significant practical implications. At paragraph 14, their lordships said this: "Where a contract contains an obligation on one party to perform an act, and also provides that if he does not perform it, he will pay the other party a specified sum of money, the obligation to pay the specified sum is a secondary obligation which is capable of being a penalty. But," and this is the passage you can see on the slide, "if the contract does not impose, expressly or impliedly, an obligation to perform the act, but simply provides that if one party does not perform, he will pay the other party a specified sum, the obligation to pay that sum is a conditional primary obligation and cannot be a penalty. In my view, this is really quite a fine distinction. And indeed, the difference between primary and secondary obligations is one that has been the subject of significant debate over many, many decades across different areas of law. I was in trial in March of last year concerning a guarantee and indemnity, and working out precisely which clauses were primary and which were secondary was extremely difficult. But it's important to understand that for present purposes, the rule against penalties only applies to secondary obligations, the what happens on breach of the contract. It does not apply to primary obligations. Going back to the facts then, clause 5.1 of the contract in Cavendish's case provided that if the defendant breached the non-compete clause, he would not be entitled to any further payments. This is where it gets a bit complicated though. At least 3 of the judges, Lords Newberger, Sumption and Carnworth, thought that in reality this was a price adjustment clause, and although the occasion for its operation was a breach of contract, it was not a secondary provision. So in other words, those judges thought that the purpose of this clause was not to provide a remedy for breach of contract, but instead was to represent the reduced price that the claimant was prepared to pay for the business in light of the fact that the defendant was not going to carry out the non-compete clauses. Again, in my view, a very fine and difficult distinction to draw. And this is really not the easiest part of the judgment to understand, given that clause 5.1 only operated in the event that there was a breach of contract. It's quite difficult to see how that was not a secondary obligation. And in fact, the other 4 judges expressed their doubts about this conclusion. Lord Mance made clear that he thought the penalty doctrine was engaged on clause 5.1. Lord Hodge applied the penalty doctrine while recognising there were strong arguments for regarding clause 5.1 as a primary obligation, and Lord Toulson agreed with those parts of Lord Mance's and Lord Hodge's judgments, and Lord Clark agreed with Lord Hodge on this point. This is really the sort of case which I'm sure law students will love in years to come as they try and work out exactly what parts of the judgment formed the ratio and had majority support. But for our purposes, really the key distinction is between primary and secondary obligations, and there is real uncertainty and difficulty in distinguishing between those. It's something that reasonable people can disagree on and Supreme Court judges can disagree on. So this is not something that is easier. And we'll come back later to practical drafting tips about how you can try and spell out that an obligation is primary. But frankly, it's easier said than done, and Cavendish really shows that. Turning to the second point then, which was, are penalty clauses limited to those for the payment of a sum of money? So, for example, does the penalty law doctrine apply to a clause which provides for the transfer of property on breach of an obligation, or is it only to money clauses? And as I've already mentioned, the classic example is one which requires a party to pay a sum of money if it breaches its primary obligations, and that's what most of the cases, the vast majority of the cases, are dealing with. But there may be other types of clauses which have a similar effect. For example, an obligation to transfer property in the event of a breach, or an obligation to return payments that have already been received in the event of breach, or forfeiting a deposit already paid over in the event of a breach. So there are various possibilities. And there was an open question prior to Cavendish whether the rule against penalties was capable of applying to these types of clauses, or if it was limited to clauses for the payment of money. And their lordships answered that question as follows. Payment of a sum of money is the classic obligation under a penalty clause, and in almost every reported case involving a damages clause, the provision stipulates for the payment of money. However, it seems to us, and this is the passage on the slide, there is no reason why an obligation to transfer assets, either for nothing or at an undervalue, should not be capable of constituting a penalty. While the penalty rule may be somewhat artificial, it would heighten its artificiality to no evident purpose if it were otherwise. Similarly, the fact that a sum is paid over by one party to the other party as a deposit, in the sense of some sort of surety for the first party's contractual performance, does not prevent the sum being a penalty if the second party in due course forfeits the deposit in accordance with the contractual terms following the first party's breach of contract. This part of the judgment is reasonably clear. The rule against penalties can apply to any clause which sets out secondary obligations, those arising on breach of a primary obligation. And that includes, for example, clauses for the transfer of property, exactly as in Cavendish itself with the sale of the shares. The second key question then was what makes a contractual provision a penalty? And in answering that question, Lords Neuberger and Sumption gave detailed consideration to the many cases that had come before. And they made clear as a starting point that the question of whether a clause is a penalty falls to be decided as a matter of construction and therefore as at the time that it was agreed. That means it's considered in line with normal principles of contractual construction. The court must consider the contract as a whole, depending on its nature, formality and quality of the drafting, giving more or less weight to the wider context. That's one of the recent statements on contractual construction from the judgment of Lord Hodge in Wood and Capita Insurance Services. So the starting point is that it's a matter of construction. Having acknowledged that, their lordships then recast the rule against penalties. And at paragraphs 31 to 32, they concluded as follows. The real question when a contractual provision is challenged as a penalty is whether it is penal, not whether it is a pre-estimate of loss. These are not natural opposites or mutually exclusive categories. A damages clause may be neither or both. The fact that the clause is not a pre-estimate of loss does not, therefore, at any rate without more, mean that it is penal. The question whether it is enforceable should depend on whether the means by which the contracting party's conduct is to be influenced are unconscionable, or, which will usually amount to the same thing, extravagant by reference to some norm. Then paragraph 32, which you can see on the screen and is the most important part of this judgment. The true test is whether the impugned provision is a secondary obligation which imposes a detriment on the contract breaker out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. The innocent party can have no proper interest in simply punishing the defaulter. His interest is in performance or in some appropriate alternative to performance. That is essentially the new test for whether a clause is a penalty or not. And if you take only one thing away from this talk, then it should be this passage. The old test of genuine pre-estimate of loss has been replaced. The new test is whether the clause imposes a detriment which is out of all proportion to any legitimate interest of the innocent party, in the sense that it is extravagant or unconscionable. Importantly, a clause which is a genuine pre-estimate of loss is unlikely to be a penalty clause because the innocent party is taken to have a legitimate interest in being compensated for the breach. But the Supreme Court made very clear that even if a clause is not a genuine pre-estimate of loss, the innocent party may still have a legitimate interest in its enforcement. So turning back to the facts again, in Cavendish, there was a legitimate interest in the observance of the non-compete clauses because the goodwill of the business was critical to its value. And although the clause did not represent a genuine pre-estimate of loss, because it was impossible to say with any certainty how much less the business would be worth in the event of a breach of the non-compete clauses, it nonetheless protected a legitimate interest and was proportionate to that interest, and so it was not a penalty. Likewise, in ParkingEye, the other joined case, Lords Neuberger and Sumption held that although ParkingEye was not liable to suffer a loss as a result of overstaying motorists, it had a legitimate interest in charging them, which extended beyond the recovery of any loss. That legitimate interest was in ensuring that car parking spaces were always available in order to ensure that ParkingEye's business scheme could operate effectively. To that extent, deterrence is not penal if there is a legitimate interest in influencing the conduct of the contracting party. This was a rather frustrating conclusion for anyone who's ever had the misfortune of receiving a penalty notice in a car park, and I speak from bitter experience here. According to the Supreme Court, such fines are probably not unenforceable penalties, as the car park owner has a legitimate interest to protect. So what is clear from the facts of both ParkingEye and Cavendish is that what constitutes a legitimate interest is a broad question. Aside from the examples given in Cavendish itself, there is not, and there never will be, an exhaustive list of the sorts of things that might constitute a legitimate expectation. Chitty on Contract suggests quite a long list, which you can see on the slide, and I won't read out all of those, but some of the examples given in Chitty would be if the claimant would face serious difficulties in proving what loss, if any, flowed from the breach, if the claimant would face serious difficulties in detecting whether there had been a breach, or if loss will be suffered by a third party rather than by the claimant, or if having to claim damages from the defendant would put the claimant's solvency at risk, or if the defendant's default meant that the claimant faced a greater risk in the future. And more generally, deterrence can be an essential element of a lawful scheme. And these are just examples, and there may well be many more legitimate interests justifying the inclusion of a clause. Suffice it to say, for now, and I will come back to this, that in drafting a liquidated damages clause, it is imperative to think about which of your client's interests that clause is intended to protect, whether that interest is legitimate, and whether the remedy set out is in proportion to protecting that interest. One final point to make about the judgment is the emphasis placed on equality of bargaining power. Lords Neuberger and Sumption said that in a negotiated contract between properly advised parties of comparable bargaining power, the strong initial presumption must be that the parties themselves are the best judges of what is legitimate in a provision dealing with the consequences of breach. Their lordships did not give much further consideration to this point, but it certainly seems likely that legitimate interest will potentially have an even broader meaning in cases like the ones you're probably going to be dealing with, involving complex, carefully negotiated contracts between experienced commercial parties. In practical terms, the courts are going to be less likely to find that penalty clauses exist in such complex commercial contracts, precisely because the parties can be trusted to identify their own legitimate interests and draft clauses which proportionately protect those interests. The decision in Cavendish has since been applied in numerous cases. It is now the leading authority in this area of law and will, I suspect, for many, many years to come. I won't go through the many cases that have applied it, but there are two examples which I think it is helpful to look at briefly. The first deals with the knotty question of primary and secondary obligations, whilst the second is an example of a case in the post-Cavendish era in which the court found an unenforceable penalty clause to exist. So the first case is Hollyoake and Candy, 2017, and that was a claim for 132 million involving a loan agreement. The facts were very complicated, so I won't go through them here. For present purposes, all we need to know are that there were two key clauses in the loan documentation which were alleged to be penalties. They were first a clause requiring the borrower to pay a redemption amount on early repayment of the loan, such that he could not avoid repaying 17.74 million even if he repaid the loan early. And secondly, a clause in a separate escrow deed that said that if the claimant did not refinance or repay the debt under the original loan agreement, a new debt of 17.74 million would arise. So clauses that are absolutely making it clear that there will be no way of getting out of paying 17.74 million. Mr. Justice Nuji decided that these clauses did not amount to penalties on the basis that they were not secondary obligations. They were primary obligations and so not subject to the penalty clause regime. At first, as to the redemption amount clause, the obligation to pay arose not upon breach of the loan agreement, but upon early repayment. So in other words, this amounted to a conditional primary obligation, a primary obligation in the contract which arose on the occurrence of a non-breach event. So it was triggered on the event of early repayment, not on breach. And because it wasn't triggered by breach, it could not be a secondary obligation, and so could not be a penalty. Secondly, the escrow deed clause did operate upon breach, but importantly, not upon breach of the escrow deed itself. Again, the obligation to pay arose upon a condition occurring, but namely breach of a different agreement. And so it was not a secondary obligation. It was upon breach of another agreement rather than breach of the agreement it was in. And so Mr. Justice Nuji said that it was not a secondary obligation. But he did note that this may just be an example of clever drafting. And indeed, I think that is right. And these examples again show the importance of the distinction between primary and secondary obligations and the difficulty in identifying which is which. By characterizing a clause as a conditional primary obligation rather than a secondary obligation, it may well be possible for contracting parties to completely avoid engaging with the penalty clauses regime at all. And that really highlights the importance of creative and clever drafting, which I'll come to in a moment. The second case I want to briefly mention is Vivian Westwood Limited and Conduit Street Development Limited, 2017. It's worth looking at because it's a rare, relatively rare post-Cavendish case in which the court found an unenforceable penalty to exist. The case involved a lease between the claimant tenant and defendant landlord at an initial rent of 110,000 per annum. This was accompanied by a side letter in which the landlord agreed to accept a lower rate of rent from the tenant. And the side letter also provided that if the tenant breached any of the terms of the side letter or the lease, then the tenant would be obliged to pay the higher rate with retrospective effect. And the tenant defaulted on the rent, and the landlord asserted that the higher rent was payable retrospectively as well. And the tenant argued that the terms of the side letter amounted to an unenforceable penalty. Timothy Fancourt QC held that the clause was a penalty. He recognised that there was a legitimate interest protected by the clause in the side letter. That was the landlord's general financial interest in having a performing tenant. However, he found that the higher rent is payable here with retrospective effect as well as for the future, in addition to the other remedies the landlord has for breach of any tenant obligation of the lease. And that consequence is out of all proportion to the legitimate interest of the lessor. You will recall those were the words of the test given in Cavendish. And importantly, the judge reached this conclusion even in light of his finding that the two parties were well advised and there was equality of bargaining power. And he described two factors as being particularly relevant. First, that the rent increase applies for whatever remains of the first 10 years of the term, regardless of the nature and seriousness of the non-trivial breach of contract and when it has occurred. And second, the increased rent is payable in addition to interest on any overdue payment, any costs incurred by reason of the breach, and damages for losses caused by the breach. Put simply, the two factors that tipped the balance were that the penalty was essentially indiscriminate and could amount to a tenant being punished quite seriously for a very minor default on rent payments. And secondly, that there were other remedies available in respect of such breaches which would adequately compensate the landlord. And those factors made this clause disproportionate to the landlord's legitimate interest of receiving income under the lease. There's no need to look for precisely these factors in every case in which you suspect there might be a penalty clause. These are just examples of the sort of things which might, following Cavendish, lead a court to find that a clause is a penalty. So in light of all that, I come to the question of how you should ensure that clauses in a contract that you are drafting are not struck down as unenforceable penalties. And in short, there are really 4 points to think about, set out on the slide. 1, does the clause create a primary obligation or a secondary obligation? 2, does the clause protect a legitimate interest? 3rd, is the clause a proportionate means of protecting that legitimate interest? And 4th, does the contract make it clear that each side was of comparable bargaining power and has been fully advised by lawyers? And I'll just briefly go through each of those points, starting with primary obligations. As I've already discussed, there is significant scope to draft clauses in such a way as to avoid engaging with the penalty clauses regime altogether, namely by ensuring that the obligation to pay amounts to a primary obligation rather than a secondary one. And as I've already said, this may be easier said than done, given the level of uncertainty about the distinction between these two. But the cases do provide several examples. So the contract could provide for some consideration for the payment, for example, an extension of time to repay a loan. And so the payment isn't being made on breach, it's being made in exchange for consideration. The clause could be drafted as a conditional primary obligation. That is to say, a primary obligation which arises on a particular event other than breach of contract. Another possibility from Holyoake and Candy is to include a liquidated damages clause in a separate agreement, such that it arises on the condition of breach of the first agreement not on breach of the agreement in which it is contained. That makes it a conditional primary agreement, primary obligation, sorry. Failing all else, it never hurts to state in the clause that it is a primary obligation. That will not be determinative in a court, but in the context of commercial contracts, it's likely to carry at least some weight. We turn then to the second question. Even if you think the clause is a primary obligation, it is prudent to consider whether the client has a legitimate interest which is protected by the clause. There's usually a legitimate interest in being compensated for breach of a primary obligation, but there's also a wealth of other legitimate interests, such as the interest in preserving a company's reputation or influencing the other contracting party's actions, or to compel the customer to move their car so you can maintain a functioning car park system. There are numerous legitimate interests, and I've referred you to the list from Chitty on contracts as to some possible legitimate interests. And really, it's going to be decided on a case-by-case basis. What is the legitimate interest here that the clause is seeking to protect? And when drafting a contract, when drafting these clauses, it's important to identify what legitimate interest you are protecting by drafting this clause. Third, as well as identifying what legitimate interest, it's important to consider whether the steps taken by that clause to protect the legitimate interest are proportionate and not exorbitant. And again, what constitutes proportionate will depend on a case-by-case analysis and will depend upon the nature of the legitimate interest. It may be that a clause can go quite far in protecting a legitimate interest if that interest is particularly important to your client. And the best example is Cavendish itself. I've already mentioned the relevant clause in that case required the defendant to sell the remainder of his business and receive no further payments from it. And at least some of the judges thought that was a proportionate means of protecting a legitimate interest because the goodwill in the business was such an important aspect of the business and the sale. It's clear from that case the consequences can be quite harsh before a judge will decide that they amount to extravagant, unconscionable, and therefore unenforceable penalty clauses, provided there is a sufficiently important legitimate interest at stake. And similarly, we know from the Vivian Westwood case that clauses which provide for the payment of money in respect of a number of breaches of varying levels of severity, so in other words, where a clause is indiscriminate, is likely to be disproportionate. And I think that makes sense because it's difficult to see how the payment of a fixed sum can be proportionate to a legitimate interest if it's payable regardless of the extent to which that interest has actually been interfered with. Unfortunately, I can't give you a hard and fast rule by which you can identify whether the clause represents a proportionate means of protecting a legitimate interest. You just have to think carefully about the legitimate interest protected by the clause, how important that interest is to your client, and ensure that the clause you have drafted is not an overzealous way of protecting it. Final point, if legitimate interests and proportionality all seem a bit vague, you can draw some comfort from the fact that courts are, since Cavendish, generally more reluctant to interfere with the commercial parties' allocation of risk between themselves. So in light of this, it may be prudent, if it's not already clear, to include in the contract a recital providing that the parties agree that they have negotiated the contract with the advice of competent lawyers and that they have comparable bargaining power. Ordinarily, of course, it may be fairly self-evident that a contract has been negotiated by experienced commercial parties who have been properly advised. But that said, there's rarely much to lose by spelling it out in the contract itself.